If you are Haitian or you have Haitian family in the United States and you just saw a headline that sounds like deportations to Haiti got stopped by a judge, you might be feeling two emotions at the same time: relief and fear. Relief because maybe it buys time. Fear because you do not know if it applies to you, how long it lasts, or what happens next. And if you are not Haitian but you follow immigration news, you might be thinking, does this change enforcement in general? Is this a big shift, or is this just a momentary court fight that will vanish in a week? Here's the truth. This kind of headline can be deeply misleading unless you understand what the judge actually did and what the government is still allowed to do. So, in this video, I'm going to break it down in plain English, step by step, with no hype, no doom, and no magical promises. I have spent years reading these court orders, watching how they play out in real life, and translating the legal language into what it means for regular people making real decisions. And by the end, you will know what the court order does, who it likely covers, what it does not do, and what smart next steps look like if you or someone you love is worried about removal to Haiti. Now, let us start with the core event. A federal judge issued an emergency order that temporarily pauses certain deportations to Haiti. Temporary is the key word. In legal terms, this is often called a temporary restraining order. People hear that and they think, okay, the judge just banned deportations. But that is not what it means. Think of it like a judge saying, stop for a moment. Do not take the next irreversible step while I look at whether the rules are being followed and whether people are facing immediate harm. It is a pause button, not a final why this ruling is making headlines verdict. It is the court saying, I need time to review the arguments before the situation changes in a way we cannot undo. That is why these orders show up in fast-moving immigration cases. Deportation can happen quickly, and once someone is put on a plane and removed, it becomes much harder to fix mistakes, even if a court later decides the process was unlawful or unfair. So, a temporary restraining order is the judge trying to preserve the status quo long enough to hold a more detailed hearing. That is the framework. Now, why Haiti specifically? Because the lawsuit behind the order argues that sending people back right now can be unusually dangerous due to the conditions on the ground. Haiti has been facing serious instability and violence, especially in and around the capital. People are talking about armed groups controlling neighborhoods, kidnappings, breakdowns in essential services, shortages, and a general security crisis that makes day-to-day life unpredictable and, in some places, life-threatening. Multiple international and United States government sources have issued warnings about travel and safety. That matters because when courts review deportation practices, they are not just asking, does the government have authority to enforce immigration law? They are also asking, were procedures followed and did the government consider the risk of harm in the way the law requires? The lawsuit claims that the way deportations were being carried out did not provide enough notice, access to counsel, or meaningful opportunity to present protection claims for certain people. The plaintiffs are basically saying you cannot rush removals in a way that strips people of a fair chance to argue that returning what the judge actually did would put them in danger. The government generally responds by saying, we do have procedures, we evaluate cases, and enforcement must continue. Then the judge looks at the evidence, the urgency, and whether the plaintiffs are likely to suffer irreparable harm without an immediate pause. That is how these emergency orders are decided. The most important thing you need to understand is who is and is not affected. Headlines make it sound like an entire nationality just got protected. That is almost never how it works. These orders usually apply to a defined group, often people directly connected to the case, such as individuals facing imminent removal who are part of the lawsuit, or people within a category the judge describes in the order. So if you are Haitian and you are in the United States, this does not automatically change your immigration status. It does not automatically grant you lawful presence. It does not automatically cancel your removal order. It does not automatically stop every immigration appointment you have. What it generally does is prevent the physical act of removing certain people to Haiti during the short window while the judge takes a closer look. That is why you have to resist the two extremes you will see online. One extreme says everything is frozen forever. That is not true. The other extreme says it does not matter at all and deportations will resume tomorrow. That is also not always true. A temporary pause can be life-changing for someone who had a plane scheduled, but it is still not a final outcome. It is a doorway into the next stage of litigation, which is where the real battle happens. So, what happens next? After an emergency pause, the court typically moves quickly into a more formal process. Both sides submit written arguments explaining their position. The government will argue about authority, enforcement needs, and existing safeguards. The plaintiffs will argue about due process, danger, and whether the government complied with statutory and constitutional requirements. Then the judge decides whether to extend the pause in a longer form, often called a preliminary injunction. That is still not permanent, but it can last months while the case continues, or the judge can lift the pause and allow removals to resume. Another possibility is that the government appeals to a higher court. Appeals are common in high temporary pause versus permanent protection impact immigration cases because the executive branch often wants to preserve flexibility and avoid setting a precedent that limits enforcement. Appeals also add uncertainty because you can have one judge pausing a practice and another court later narrowing or reversing it. That is why smart planning does not rely on a single headline. It relies on your individual case posture and on professional guidance. Now let me address a big source of confusion that gets mixed into Haiti news all the time, and that is temporary protected status, commonly called TPS. TPS is a program where the United States can designate a country for temporary protection when conditions there may return unsafe, such as armed conflict, environmental disaster, or other extraordinary conditions. Haiti has had TPS designations in different periods for different reasons, but TPS is not automatic and it is not universal. You typically have to apply. You have to meet eligibility requirements, and there are often date-based rules about when you must have been in the United States. Some people miss deadlines or do not qualify because they arrived after the cutoff. Some people apply and get denied. Some people never apply because they do not know they might be eligible. So you can have two Haitian neighbors living on the same street, and one is protected by TPS with work authorization, while the other has no TPS and is in removal proceedings. That is why broad statements like Haitians cannot be deported are so dangerous. In many cases, people with valid TPS are already protected from removal while their TPS is in effect, but people without TPS may still face removal unless they have another form of relief or a court order covers them. So when a judge pauses deportations to Haiti, it often intersects with people who do not have TPS and are facing imminent removal. It does not replace TPS and it does not create TPS. It is a separate court-driven action focused on procedure and immediate risk. Now, let us talk about the practical question everyone asks next. What should I do right now if I am Haitian and I am worried about deportation? I am going to be direct. You should keep doing what you are required to do unless a lawyer tells you otherwise based on your case. That means if you have an immigration court hearing, you go. If you have a check-in appointment with immigration authorities, you go. If you have biometrics, you go. Skipping obligations because you think a judge paused deportations can backfire badly. Even in situations where a pause exists, missing a court date can lead to an in absentia removal order, which can create bigger "who is covered by this order" problems. You do not want to make your case worse based on a misunderstanding. What you do instead is you confirm whether the order applies to you and you discuss strategy with a qualified immigration attorney or accredited representative. If you are someone with a final order and you were recently told you may be removed soon, you should treat this as urgent. A temporary pause can create a small window where lawyers can file motions, request stays, gather evidence, and present protection claims. But that window is only useful if you act quickly. Do not wait for the internet to tell you what to do. Now, I want to make this feel real because legal talk can sound abstract until you picture a person living through it. Imagine a man named Gene. He has been in the United States for several years. He does not have TPS because he arrived after the most recent cutoff date. He has been fighting his case in immigration court, and he loses. He receives a final removal order. He is told he needs to report for a check-in, and there is a possibility of detention and removal. Gene has a job. He has a child in school. He is terrified. Then he sees a viral clip saying, "A judge stopped deportations to Haiti, and he thinks I am safe." So he decides not to go to his check-in. That is a disaster scenario because even if removals to Haiti are paused for a small group, immigration can still detain someone, can still enforce reporting requirements, and can still penalize failures to appear. Jean might get labeled as someone who failed to comply. He might lose chances to reopen his case. He might make himself a priority. The smarter move for Jean is to go to his appointment, bring proof of any pending filings, and have an attorney involved. If he cannot afford an attorney, he needs to contact reputable nonprofit legal clinics, immigrant rights organizations, or local legal aid groups that handle removal defense. The point is not to hide. The point is to respond with strategy. A court pause is not a force field. It is a procedural moment that can be leveraged if you take the right steps. Now, let us break down what the pause does not do because this is where the rumor machine goes wild. It does not stop immigration enforcement across the United States. It does not stop deportations to countries other than Haiti. It does not mean that everyone from Haiti can stay permanently. It does not mean you can ignore your case. It does not mean the border is open. It does not mean there is a new law that guarantees protection. It is a specific judicial action tied to a specific lawsuit and the specific claims in that lawsuit. Some people also, who is not protected, use these moments to push political narratives, saying, "This proves deportations are illegal," or "This proves an administration got defeated." That framing is usually not helpful. Courts do not generally operate like a scoreboard for politics. A judge can pause a practice because the plaintiff showed a credible argument about procedure and harm without making any broad statement about enforcement. Overall, immigration agencies have significant authority to enforce the law. That authority generally remains intact. What courts do is supervise the boundaries, making sure agencies follow statutes, regulations, and constitutional requirements. So the big picture is not that enforcement ends. The big picture is that enforcement has rules, and sometimes courts step in when they believe the rules may not be followed properly in a particular context. Now let us talk about why courts care so much about procedure in deportation cases. Because in immigration, procedure is often the difference between safety and danger. The law typically requires that people have a meaningful chance to present claims for protection if returning would risk serious harm. You might hear terms like asylum, withholding of removal, or protection under the Convention Against Torture. Those are different legal pathways with different standards. But the common idea is that in certain situations, the United States may be prohibited from returning someone to a place where they would likely face persecution or torture. These are not easy cases. They require evidence, they require credibility, they require legal arguments, and if the process moves so fast that someone cannot contact counsel, cannot gather documents, cannot explain what happened to them, then the legal protections become meaningless. That is why lawsuits often focus on due process, which in plain terms means fair procedure. Even non-citizens on United States soil often have certain procedural protections, not the same as citizens in every way, but not zero either. So when a judge pauses removals, the judge is often responding to an argument that the process is not giving people a fair shot to raise legal protections. Now, how long can a temporary restraining order last? Often it is short, sometimes around 2 weeks, how this affects TPS holders, but it can vary and it can be extended. The key is that it is designed for immediate emergencies, not for final resolution. That is why you should treat it like a short runway. If you are covered, you have time to prepare the next steps. If you are not sure you are covered, you have time to verify quickly. Either way, you should not treat it as a long-term plan. Your long-term plan is built around your actual immigration options. That brings us to the action plan portion of this video, because information without action just creates anxiety. Step 1 is clarity about your current status. Are you in court? Do you have a pending application? Do you have TPS? Do you have an order of removal? Do you have a future hearing date? Many people do not even know exactly where they are in the process because they moved, they missed mail, or they relied on someone else to handle it. You need your paperwork. Keep physical copies and digital copies if possible. Court notices, receipts from USCIS, work permits, prior decisions, anything with an A number. If you ever need to show a lawyer your history fast, you do not want to be searching through old text messages and faded envelopes. Step 2 is communication. If you have an attorney, contact them and ask what this court action might mean for your case. If you do not have one, look for reputable help. I am going to say something that may save you from a terrible mistake. Be cautious of people who claim they can fix your case if you pay them, especially if they promise guaranteed results. Immigration is complex and no one can ethically guarantee an outcome. In many communities, there are unlicensed consultants who use titles that sound official. Some call themselves notaries or notarios. The problem is that in the immigration context, those terms can hide unauthorized practice of law. They may file the wrong forms, miss deadlines, or take money and disappear. You want a licensed attorney or a Department of Justice accredited representative. If you are unsure, you can ask for credentials and verify them. Step 3 is deadlines and attendance. Keep every appointment. Update your address with the court and with USCIS if you move. Missing mail is one of the easiest ways to lose an immigration case. Real example: what happens to someone facing removal because you can miss a hearing notice or a request for evidence? People think they will call me. They often will not. The system runs on written notices. Step 4 is relief options. If you may qualify for TPS and there is a current designation and you meet the eligibility rules, explore it quickly. If you have a credible fear of harm upon return, explore protection-based options with legal help. If you have a family-based path, explore it. If you are eligible for any motion to reopen based on changed country conditions, explore it. I am not saying you qualify because it depends on facts, timing, and prior history. I am saying you do not leave stones unturned while you have a window. Step 5 is personal preparedness. This is the part people avoid because it is emotional, but it matters. Have a plan in case you are detained, who will pick up your children, who has access to important documents, who can contact your lawyer. Keep key phone numbers written down, not only stored in your phone because phones can get lost or taken. If you take medication, keep a list. Being prepared does not mean you are giving up. It means you are protecting your family from chaos. Now, let us address another big fear. People ask, does this mean enforcement is increasing? In many periods, enforcement priorities and intensity can shift. Sometimes you see more worksite actions, more targeted operations, more detention capacity, or more cooperation between agencies. At the same time, you also see legal challenges and policy updates. These forces move at the same time. Enforcement does not stop because lawsuits exist. Lawsuits do not stop because enforcement exists. They coexist. Courts act as a check, but they do not run the agencies. So the realistic mindset is this: enforcement can continue broadly while a specific practice is paused in a specific context. That is why you should not interpret a Haiti-related order as a global shutdown. It is better to think of it as one lane of a highway being closed while construction happens while the rest of the highway still moves. Now, before we get to the second example story, I want to talk about information hygiene because the speed of misinformation is part of what is harming people. Social media clips often cut out the important details. A court order might apply to a narrow group, but the viral post will say, "Deportations, what the government will likely do next stopped." Then people make life decisions based on the wrong story. Here's a simple rule. If a claim about immigration fits neatly into one sentence, it is probably missing context. Real immigration updates usually include who is covered, what dates matter, what filings matter, and what exceptions exist. So, when you see a big claim, slow down and ask, what is the source? What does the actual order say? And what do reputable legal organizations say? Official sources can include USCIS updates, Department of Homeland Security statements, and published court documents. Reputable nonprofit legal organizations and established immigration law groups often provide clear analysis too. You do not have to become a lawyer, but you do have to be careful about the inputs you trust. Panic gets clicks. Accuracy takes longer. Choose accuracy. Now for the second example story, because this one shows how a temporary pause can actually help when used correctly. Imagine a woman named Marie. She is Haitian, she has been in the United States for a long time, she applied for asylum years ago, but her case got complicated and she eventually received a removal order. She has been checking in with immigration, trying to follow the rules, trying to keep her job and care for her elderly mother. Then one day, she is told there is a real possibility she could be removed soon. Marie does not run. She calls a reputable legal clinic. They review her file and notice something important. The situation in Haiti has changed significantly since her last "What You Should Do Right Now" hearing, and there may be a legal pathway to ask the court to reopen her case based on changed country conditions, depending on the facts and on what evidence they can gather. They start collecting reports, statements, and documentation. They also prepare a request to pause removal while the court considers the motion. Then the federal judge issues an emergency pause affecting certain deportations to Haiti in a related legal context. That pause gives Marie time. Not a guarantee, not a miracle, but time. Time to file correctly. Time to gather evidence. Time to put her story in front of a decision maker in the way the law requires. That is what these pauses can do at their best. They can create breathing room for the legal system to function as intended. But notice what made the difference. Marie acted. She did not assume. She did not rely on a rumor. She used the time to pursue proper legal steps. That is the mindset you want. Now, let us zoom out and answer the question everyone asks quietly. Will this pause last? Nobody can promise you that. Courts can extend these orders into longer injunctions. Courts can narrow them. Higher courts can step in. Negotiations can happen. Agencies can adjust procedures to address the court concerns. There are many paths, so what you do is you prepare for multiple outcomes. If the pause is lifted, your case strategy should still be in motion. If the pause is extended, you use the time wisely. Either way, you do not freeze and you do not gamble your future on a single court filing. Now, I want to cover something that is both practical and sensitive. If immigration agents come to your home, what should you do? In general, you have rights. You can remain silent, you can ask to speak with an attorney, you can ask for documentation. Entry into a home typically requires proper legal authority, and there is a difference between different types of documents. People often confuse administrative paperwork with a judicial warrant. The details can matter, and the safest approach is to stay calm. Do not lie. Do not run. Do not sign anything you do not understand and ask to speak with counsel. If you live with others, talk in advance about what to do so that common misinformation explained nobody panics in the moment. Preparation reduces harm. Now, let me bring it back to the core message because we have covered a lot and I want you to have a clean takeaway. A federal judge issued a temporary pause affecting certain removals to Haiti likely because the court saw serious questions about safety and about whether procedures were followed properly. This is not permanent protection. It does not automatically apply to every Haitian national. It does not end enforcement. It is a narrow legal moment that can provide critical time for some people. If you or someone you love is at risk of removal to Haiti, the smart response is not celebration and not despair. The smart response is verification and action. Verify whether the order covers you. Keep attending your obligations. Get qualified legal help quickly. Organize your documents. Explore relief options that fit your facts. Avoid misinformation and have a final takeaways, A+ what comes next family plan so that fear does not control your decisions. Here is a final mini recap so it sticks. A temporary court pause is a pause, not a promise. It buys time. It does not grant status. It may cover a specific group, not everyone. The next stage is a deeper hearing and possible appeals. During that time, your best move is to stay engaged with your case and get real guidance. Now, if you want me to keep covering updates like this in a way that is clear and practical, subscribe so you do not miss the next breakdown. If you found this helpful, tap like so more people who are confused can find it. And if you have a question about your situation or a topic you want covered next, leave a comment with the country and the type of issue like TPS, asylum, court hearings, or enforcement. I read the comments and they guide what I explain next. And if you want to keep going right now, watch the next video on your rights during an immigration encounter and the documents you should have ready because those two things often matter most when headlines turn into real nice.